Thanks again for attending, everybody. My name is Mitchell Zaddo. I'm the Managing Principal at Sharrock Pittman Legal, and thank you very much for joining us today for our webinar on legal professional privilege. Before we get started, we would like to acknowledge the Wurundjeri people of the Kulin Nation as the traditional owners of the land on which our office is located, and we pay our respects to their elders past, present and emerging, and acknowledge that sovereignty was never ceded. And we extend this respect to all First Nations communities throughout Victoria and wherever you may be logging in from. I know many of you have attended our webinars before, so welcome back, and an especially warm welcome if this is the first time you've attended one of our webinars. We hope these are a really helpful resource just for us to share with you some of the things that we're seeing in our day-to-day practice and that we think would be beneficial for you to have some awareness and knowledge about. We've done webinars on all different topics now from across the firm. And if you go to our resources page on our website, you'll see the recordings there from all the previous webinars from commercial law and business law, property law, employment law, not-for-profits and wills and estates, and of course, litigation disputes, which is the theme for today. Today's session is being recorded as well. So if you lose track of anything or want to revisit it, feel free to log on later on. We'll let you know when the recording is available. Today we're looking at the concept of legal professional privilege, as I said. It's a term you may have heard of, but you may not have actually needed to know exactly what it means unless you've perhaps been involved in a dispute or litigation or needed to consult with a lawyer about something. It is something we think is good for you to have a good working knowledge about because you never know when legal advice or a dispute may arise and perhaps become necessary or even inevitable. Obviously, if you are in a dispute, your lawyer should be giving you some advice about that, but it's good to have some background knowledge as you're going about things. I'm joined today by Caroline Caligari and Sonali Mola from our litigation team. Caroline's an associate principal here at Sharrock Pittman Legal and leads that area of our practice. And she and Sonali are dealing with these things every day, day in and day out. So I know they're keen to share with you some tips today. Before we begin, some housekeeping items. We are recording the session, as I said, and it will be available on our website soon. If you have any questions, please feel free to type away in the Q&A function in your Zoom. We'll try to get to questions as we go. We'll also allow some time for questions at the end, but we are conscious of everybody's time. So if we get close to the end of the hour and we haven't addressed all of the questions, don't worry, we will get back to you afterwards. And we will put our contact details up on the screen again at the end as well. So do feel free to get in touch afterwards. I can see one question has come through already. I might leave that for the time being because that might be addressed by Caroline and Sonali as we go through the session. Before we continue, and I hand over to Caroline and Sonali, we are lawyers after all, so a little bit of fine print. If forgive me, obviously today we can just talk about things in general terms. It can be a complex and messy area, so do get advice on your own circumstances before doing anything. All right, without further ado, I'll welcome Caroline and Sonali. Thank you, Caroline.
I'm going to jump in. Sonali's going to start, but this is a really practical session. So we're not going to deep dive into the law. We're going to kind of give you the headline issues and some headline examples. So we're looking to give you a really practical session. In relation to the question, I saw it and the answer will be given to you when we switch back to me after Sonali. But if you have a look, we're going to start with a bit of an introduction. We will cover what is privilege, key elements to determine if something is privileged, why it's important, and give you a case study in relation to waiver of privilege and the state when it involves a state of mind. Then we'll give you some practical examples of when privilege is waived, along with a little bit of information in relation to the law, and then tips and tricks on how to protect your privilege. And then there's an opportunity to ask additional questions. But as Mitch said, feel free to put them in the box and we'll try and address them as we go along. So without further ado, I'm going to pass you on to my colleague Sonali, who is going to address the first part of our seminar and give you a brief guide to what is privilege.
Thank you, Caroline. Thank you, Mitchell. So generally speaking, legal privilege, it's sometimes referred to as legal professional privilege or client legal privilege. It is a common law right designed to safeguard the administration of justice and to ensure that both individuals and organisations can receive confidential legal advice regarding their circumstances. Now, the purpose of privilege is to protect confidential communications and confidential documents between a lawyer and their client, primarily for the purpose of the lawyer providing their advice for an impeding or current litigation in their client's matter. Now, specifically, there are two different types of privilege, one being advice privilege and the other being litigation privilege. Now, next slide, please. Thank you. So advice privilege is a protection of the communications between a client and a lawyer in which the confidential documents are prepared by a client, lawyer, or third party are prepared for the primary purpose of providing legal advice. A lawyer can only disclose such advice if their client has clearly instructed them to do so. Also, for the purpose of keeping information privilege is to aid in the open communication between lawyers and their clients, allowing clients to speak freely and help lawyers get to the crux of their client's matter. Now, litigation privilege protects the confidential communications and documents prepared for the dominant purpose of current or upcoming proceedings. Here, a document could be defined as letters, notes, computer files, emails, and minutes of meetings. There are two different categories of communications that can warrant privilege. One is between a lawyer and their client, and some between a lawyer and a third party, such as an expert. The Evidence Act also provides some guidance as to what sort of privileged client communications can be admitted into evidence in litigation proceedings. Similarly, there are common law protections such as discovery that hold a similar vein of protection for privileged information. Now moving on to the key elements of privilege. There are two limbs, the first being the dominant purpose test. This is evidenced in the Evidence Act in Victoria from 2008 in sections 118 to 119, and at common law, it was brought about in the decision of ESSO Australia Resources Limited and the Commissioner of Taxation in 1999. They provide that the communications or documents be made or produced for the dominant purpose of providing legal advice or actual or anticipated legal proceedings in order for privilege to apply. Now, section 118 of the Evidence Act provides that evidence is not to be adduced if, on objection of the client, the court finds that adducing the evidence would result in the disclosure of confidential communication made between a client and a lawyer, or B, a confidential communication made between two or more lawyers acting for the client, or C, the context of the confidential information, whether it was delivered or not, prepared by the client or the lawyer for the dominant purpose of the lawyer or one or more of the lawyers providing legal advice to the client. Now, section 119 of the Evidence Act applies more so to litigation. And now this section states evidence is not to be adduced if, on objection by a client, the court finds that adducing the evidence would result in disclosure of either A, a confidential communication between a client and another person, or between a lawyer acting for the client and another person that was made, or B, the context of a confidential document, whether it was delivered or not, that was prepared for the dominant purpose of the client being provided with professional legal services in relation to Australian or overseas proceedings before the court, and whether they be anticipated or pending proceedings in which a client is or may be or might have been a party. Now, the burden of proof of privilege in the dominant purpose test lies with the party who is claiming that this document is privileged. Also, if the document and or the communication is subject to both legal and non-legal advice, only the portion contained in legal advice will be subject to privilege. Now moving on to the second key element, being confidentiality. The second limb is claiming that a document or communication is privileged and should not be disclosed in proceedings is that it must have been made confidentially, in that there was an express or implied obligation not to disclose its context, and that can be found at section 117 of the Evidence Act. And this would also mean that privileged information that is made in front of a third party will not be considered privileged. Now, moving on to a case example. And now, as I briefly mentioned earlier, privilege can extend to communications between lawyers and third parties, such as experts. The case of Gorbenzade in Western Sydney Local Health District illustrates that an expert's working notes could be considered protected under privilege. This New South Wales Supreme Court ruling affirmed that any written materials produced by a medico-legal expert while offering a preliminary verbal opinion to instructing solicitors may also be needed to disclosed in court proceedings. Now, this case involved a letter of instruction that was issued to the expert for the defendant in this case, which included several documents for this expert's review and a request to be available for discussion for his verbal opinions on these documents. Now, in preparation for his discussion, the expert prepared written notes. Later, at the request of the defendant, a further letter of instruction was issued requiring the expert to produce a report. The plaintiff later issued a subpoena against the expert for production of all documents relating to the preparation of his report, but the defendant argued that his handwritten notes were subject to legal professional privilege. Now, the plaintiff alleged that this document was not covered by privilege, and if it was waived by the defendant. His Honour noted that typically an expert's documents used to prepare their expert report are not considered privileged. The court found here that the expert's handwritten notes were used to form his verbal opinion and were not a communication and were therefore not the subject of privilege, as it was waived due to the relevance of these notes to the final written report. Now, this decision also emphasises that separating a request for a verbal opinion into a separate letter of instruction from a later request for a written report will not adequately protect any materials related to the verbal opinion from standard disclosure requirements. And now moving on to why privilege is important.
I might just jump in. I might just jump in there because I saw one of the questions that has popped up that is relevant. The question is, what about a person's diary and file notes? They're made arguably for litigation, even when litigation isn't foreshadowed. It's not like always, it's never a clear black and white answer, but it goes back to one, was it created confidentially by you and not shared with anybody? And two, was it for the dominant purpose of anticipated litigation? If there's nothing on the horizon, it's a lot harder to argue that your diary note that you've created of something that's happened at a specific time will ultimately be privileged. But if, for example, you think that there's a fight brewing and you're specifically taking those notes as your evidence that you want to then give to your lawyer to either obtain legal advice or to start litigation, they may be privileged. The question, however, will then become later on, and we don't really cover it in this seminar, but it might be another one that we might give you later on, is whether those documents, you might want to waive privilege later on, and or whether those documents are relevant and need to be discovered during the process of discovery if those proceedings are then commenced. But it will come down to the facts specific scenario and whether they were created for the dominant purpose of anticipated litigation or for the purposes of you then obtaining legal advice. And of course, if you share them with somebody else that's not a lawyer and is not for that purpose, then arguably you haven't kept it confidential and you will have waived privilege if it existed in the first place. So I'll leave you and give you back to Sonali.
All right, so finally, why is privilege important? Privilege is vital in that it allows free and open communication between clients and their lawyers. In litigation, it promotes the proper conduct of litigation proceedings by allowing said free disclosure between clients and lawyers, and in turn enables lawyers to provide proper advice and representation for their clients. A statement by Justice Wilson in the matter of Baker and Campbell in 1983 also went so far as to consider privilege as a human right by stating the adequate protection according to the law of privacy and the liberty of an individual is an essential mark of a free society, and privilege is an important element in that protection. Now, as mentioned previously, insofar as litigation proceedings go, the concept of privilege extends to documents such as expert reports, letters between lawyers and experts, such as letters of instruction, draft notes and memorandums taken during discussions with an expert, witness statements, and draft witness statements. It can therefore have significant effect on proceedings if these documents are incorrectly enclosed. It's also important to note that once a statement is filed and served, its confidentiality and therefore its privilege is lost, particularly in the pre-trial processes such as discovery, as Carolyn briefly mentioned. Ascertaining whether or not a document or a communication is privileged can be difficult. So if you're ever unsure, we would recommend speaking with your lawyers to assist you in working out what you can or cannot disclose, particularly in circumstances such as discovery, to ensure you don't end up with an adverse decision when it comes to trial. Now I'll pass it on to Caroline to discuss a case study.
Thank you, Sonali. So, as I mentioned before, this case study should actually answer the first question that came through, which was, can you please address how one should address legal privilege when being cross-examined, i.e. I relied on advice from my lawyer without waiving privilege? The answer is that's going to be really difficult. If you advised on if the state of mind is an important issue in the actual proceeding, then arguably by having relied on that advice and making a statement like, I relied on legal advice, you'll have waived the privilege and be subject to cross-examination. There are different scenarios, and again, we haven't really touched on them in this webinar because we could go on and on about it, where there are certain circumstances, like you're being cross-examined by a liquidator, where you actually can't fully maintain the privilege, but you can sort of maintain it. And in those circumstances, before you answer every single question, you actually have to say privileged to assert the privilege. That's not really covered in this webinar, and again, might be another one we'll do later on down the track. Now, in terms of the case study, the courts have held in relation to privilege that if you plead a state of mind in your pleadings, or you say something under cross-examination like, I relied on legal advice, that could have been influenced by the legal advice, there is a significant risk that you will have waived privilege in those circumstances and the advice is no longer privileged. We have two examples. One is from the High Court in 1999 in the case of Mann v. Carnell. In this case, Dr. Mann wrote a letter to a local member of the ACT government criticising how his recent case was handled. This communication was then forwarded to the Chief Minister of the ACT, Ms. Carnell. She then responded to the local member, including copies of legal advice given to the government, with the intention of demonstrating that the government had acted in accordance with their legal advice. Mann then made an application to the Supreme Court for defamation arising by the inclusion of those documents, arguing they were confidential communications by the inclusion of those documents, arguing that they needed to be disclosed. The other side argued they were confidential communications between lawyer and client and therefore didn't have to be disclosed. The decision, however, was adverse to Ms. Carnell and noted that privilege can be waived where the holder of the privilege puts forward that their state of mind, i.e. action, was based on legal advice received. So in this case, he was arguing defamation. She said, I can't have defamed him because I obtained legal advice and I was just acting in accordance with that legal advice. But unfortunately, because she included the legal advice and the substance of it in her letter to the Chief Minister of the ACT, privilege was waived. On the flip side, and this is the second case study in relation to state of mind, is the case, a more recent case from 2020 of the Australian Securities and Investment Commission of Australia versus the ANZ. In this case, ASIC commenced proceedings against ANZ regarding allegations of false and misleading representations and unconscionable conduct in relation to the fees they had charged. ASIC tried to get ANZ to produce legal advice provided to them in an earlier class action involving ANZ charging exception fees. ASIC argued that the advice given for the previous proceeding was no longer protected by client legal privilege and had been waived because ANZ had disclosed some of the advice to ASIC in correspondence and argued that ANZ would have known it had no basis for charging those fees if it had received legal advice inconsistent with its action. So they said they'd waived privilege because those documents demonstrated their state of mind. ANZ denied that their legal advice contributed to their state of mind and that their fees were charged based on their contractual obligations to reasonably do so, and the court agreed. The court said privilege was not waived and ANZ did not have to disclose their legal advice. It was for two reasons. One, the legal advice did not influence their state of mind in the proceeding, so it couldn't have been waived in those circumstances. And also because they actually hadn't disclosed, like when they disclosed some of their advice to ASIC in correspondence, they actually hadn't disclosed the totality of their legal advice and had kept it confidential. Next slide, Mitch. So moving on from those, and this is meant to be a more practical session now, when is privilege waived? At its highest, privilege is waived when the holder of the privilege, and the holder of the privilege is the client. It's not the lawyer's privilege. The lawyer can't waive it on behalf of the client unless the client gives them instructions to do so. So it's the client's privilege. And when the client acts in a way that is inconsistent with the communication remaining confidential, then privilege will have been waived. Intention is key, but you're not looking at objective intention. You can't say, well, I didn't intend to waive privilege. what you're looking at is subjective intention. And so the court is looking at whether you've acted objectively, it's not subjective, objectively in a way that's inconsistent with the communication remaining confidential. So confidentiality really is one of the keys in terms of maintaining privilege. And again, only the holder of privilege or an authorised person can waive the privilege. Waiver can be intentional, it can be unintentional, and it can be implied by the court. In relation to intentional waiver, that's usually the circumstances where either you've pled a state of mind based on your legal advice, or you've said, my lawyer told me X, Y, Z. It can be unintentional, where you accidentally slip, for example, you accidentally slip in a document that was given to you by your lawyer and that had contained legal advice and you didn't realise. And it can be implied, as in determined by the court, which is what happens in the cases where you're talking about pleading a state of mind. Privilege is usually not waived where the advice is shared within an organisation. So, for example, a company goes to their lawyers to get legal advice on a specific area of law, and then it's shared amongst the directors for the purpose of making decisions. You don't waive privilege simply by stating that you've received legal advice. However, if you then go on to say what your legal advice was, you will have waived privilege. You will not have waived privilege where you express a view on a matter after receiving legal advice, providing details of the advice itself are not disclosed. It is usually not waived where there has been an accidental disclosure, for example, sending correspondence to the wrong person or accidentally including a document in discovery, providing that you take steps to notify the receiver and request deletion or destruction without reading it straight away. And the longer the gap there is in there where you haven't realised and somebody actually may have read it, the cat at that point might be out of the bag. And this is usually where there's a lot of fights in litigation as to whether privilege has been waived. But there's also ethical obligations on lawyers who receive a document that in a litigation proceeding that they believe may have been privileged, not to actually open it and read it if it's obviously privileged. So that's why we go back to some of the tips I mentioned later on. Privilege is not waived where the communication or the document is produced under compulsion. So, for example, if you get a subpoena and privileged documents are covered by that subpoena, provided that you assert privilege, and then so effectively you've got to make an objection to production of those documents, then the court will determine. In most cases, if it's privileged, the court will say no, the other side won't get access to the documents. It's also not waived where you and another person are sharing the legal advice and you have a common interest. It most often happens where there's two defendants in the same proceeding. Their defences are a little bit different, but their two lawyers might be sharing some of the advice with each other to the extent that you have a common interest and or a common defence. In those circumstances, you're not waiving privilege, so the plaintiff's not going to get access to all of that just because the two lawyers are talking. There are some other common examples. One of them's probably important given all the stuff that's happening out there at the moment with the changes made by Jacinta Allen to planning. So where neighbours are opposing a development in a residential area and you get advice and then you're talking to your neighbours about that advice to see if they want to jump in, provided that your neighbours know to keep it confidential and you've told them, I'm telling you for this specific purpose, I'm telling you to make a decision, don't share it with others. In the circumstances between an insurer and an insured, so if you're seeking in a litigation, you've gone to see a lawyer and your lawyer said, well, you might be covered by your insurance here. This is my advice, and you pass it on to the insurer so that the insurer can determine whether to cover you, or we're your partners or JV partners, except where you're fighting with each other, of course, and you're on opposing sides. At that point in time, you don't want to be sharing your legal advice with your partner or the joint venture partner. Next slide. There can also be circumstances where there's been a limited waiver of privilege for a specific purpose where you're not waiving it to the world at large. So this is usually the example where you have an expert involved in a matter. So if you're sharing a document with a third party for a limited and specific purpose on terms that require confidentiality, and of course in dominant, where the dominant purpose is anticipated litigation or to get legal advice, then you won't have made a disclosure to the world at large. This is why you can provide, for example, if you're in a litigation, you might speak to your accountant and go, I'm in the middle of this litigation. I need X, Y, and Z documents from you, and I need you to give me these numbers so that I can then give them to the lawyer and they can advise me. In those circumstances, you would not have waived privilege, provided that you, one, have told your accountant what the specific purpose was, and that purpose is for litigation or obtaining legal advice. And of course, you've required confidentiality as from your accountant. That's usually as a matter of contract anyway, but for certainty, I usually tell them that you should also tell your accountant, please keep this confidential. It's only as between me, you, and the lawyer. Now, if in doubt about whether doing something might waive privilege, you really should seek legal advice before you communicate the document to somebody else or share your advice with somebody else or ask somebody else for assistance in a proceeding. Because once privilege is lost, you can't get it back. The cat is definitely out of the bag. You cannot get it back. So you should be really careful in what circumstances you communicate your legal advice. Now, the more practical side of things. How do you protect privilege? Some tips and tricks. It's a really tricky area. The simplest thing, and it's not the first point here, but the simplest thing is if you're in a litigation or you're going to see a lawyer and you need to get legal advice, don't talk to anybody else about it. Because talking about it, gossiping about it, telling other people what your legal advice is a surefire way for it to then get out there and for privilege to have been waived. And look, that can undermine your whole proceeding. If your litigation hasn't commenced and your advice has gotten out there and your strategy has gotten out there, etc., and the other side finds out about it, cat's out of the bag and they can use that against you. So it's always best to just keep quiet. And if you want to talk to somebody specifically, talk to your lawyer and then ask your lawyer, can I, share this, or how do I do this without breaching privilege? Some other more kind of practical tips. When you meet with your lawyer, only have people who are absolutely necessary present. There are a lot of times where people want to bring, their best friend and a whole bunch of other people as support people into a meeting. You got to be really careful in those circumstances who you're inviting with you. And it can be a fine line between you having somebody who has a common interest or is going to be there and assist you through the litigation and keep it confidential to maintain privilege. It can be quite a fine line. So if you're going to go into a meeting with your lawyer and you do want to bring somebody with you, it's probably best to ask them beforehand so that you can get the most out of the meeting and ensure you're bringing the right person. And things are also set up so that privilege can be maintained. Other examples, this is kind of more so in business, often, or for accountants or advisors, because often you might receive a subpoena, and the subpoena can be really wide in terms of its definition of documents, and it can include legal advice. As an advisor, for example, if you've been the accountant and you're assisting the lawyer in litigation, you might have had access to some of the advice or the communications. There might be communications between you and the lawyer for that litigation that are captured. Now, that's not your privilege as the accountant. That is the privilege of your client. So you've got to make sure that before you disclose the documents, because they will have to be disclosed, that you are asserting privilege on behalf of your client. In those circumstances, you might talk to your client and see whether they mind whether it's waived, and they might say, nah, it's fine. Don't, disclose all the documents, don't maintain privilege, or they might require you to make an objection. The other point in relation to this is when you're putting all the documents together, you would be putting them in a sealed envelope marked privilege and confidential. So you still have to produce them to the court, but you don't want the other side to see it. So you've got to separate the privileged documents from the other documents under the subpoena. And I usually say clearly write privileged and confidential subject to objection. And then the objection will happen. You probably should also urgently get some legal advice if you've got a subpoena that is going to require you to disclose your privileged information from your lawyer, because they can help you navigate through this process. There's nothing worse than accidentally including a privileged bit of document or a privileged communication between you and your lawyer, accidentally in a chain of emails under compulsion, the other side then reads it, you don't assert your privilege and privilege having been waived. Because often, sometimes you'll get a subpoena and then the next thing you know, you'll be involved in the litigation and all the advice you've previously gotten has been waived. Don't talk about your case, especially if litigation has been commenced. I know there's often a human need. You want to be able to talk about it and express what's going on. Don't talk about the specifics of your case. You're better off just saying to people, I really can't talk about it. In terms of expert reports, it is a lot safer and it's a lot clearer that it's covered by legal professional privilege if you get your lawyer to obtain your expert reports. It's also, and this is not me trying to get work, it can also be really important because if you haven't set it up properly, you haven't provided the instructions properly, you haven't told them to keep it confidential, you might then get a report that's adverse to you that you don't want to use in the proceeding, but you waive privilege because the way that you engage the expert has not been in the right way. So if you think there's going to be a potential litigation and that you might need an expert, you should, at least at a high level, talk to a lawyer. Either they can engage the expert on your behalf or they can at least give you some guidance on what to do to make sure that it is protected. The other thing is if you're going to seek the expert report yourself, you need to make sure that the expert knows it's for the purposes of obtaining legal advice or for potential proceedings before they start. Because then experts especially will know that that means that preliminary work is going to attract privilege. And ensure that before you get them to start on what they're doing, that they agree to maintain privilege and to keep the report confidential and only share it with you. And then when you get it, you only share it with your lawyer.
Just on that, sorry to interrupt. Just on that point, I think it's a good example of an area where this becomes relevant, even if there isn't like red hot litigation on foot. It doesn't, because it's tempting to think, oh, this happens if I'm being sued or if I'm in court, but it can happen quite early on. And we've had some situations in the employment law space, for example, where maybe an employer has received a complaint about conduct in the workplace or something like that, and it needs to be investigated. Just thinking ahead, we have been the ones to go to actually engage the workplace investigator so that the report that comes back is privileged, and that's even before it's gotten to the point of sort of lawyers at 20 paces and that kind of thing. So there can be a bit of a strategic sort of element in this, and it's never too early to think about getting ducks lined up in a row and trying to set things up so that they are protected.
Yeah, and there's similar examples, like we do a lot of shareholders disputes, and you might want to get a valuation from an accountant that you want to use in the proceeding. Again, you're thinking ahead. You might not have even started. You might just want the valuation so that you can kick off in terms of your negotiations and so forth. But again, you might end up having a fight about it. So it's always good to think ahead. Before I keep going on some of the examples too, there's a question in the box which I might answer, and it says, are communications with a counsellor or psychologist permitted to ease the stress of litigation to not waive privilege? Well, one, it's covered by confidentiality, but so you should be okay. But if you're discussing the litigation generally and your emotional state and the stress of the litigation, etc., that's not really disclosing the gist or the substance of your legal advice. And you can only really waive privilege where the substance, the gist, or the conclusion of your legal advice is provided to somebody else. So in those, those are confidential discussions. If you're not saying, my lawyer gave me this advice and this is what I'm going to do and this is what the strategy is, and you're just talking about the fact, with your psychologist, I'm in litigation, this is really, really stressful, I felt really emotional when this stuff was happening, etc. It's not going to waive privilege. And I probably should have said it before, and I'm not sure it's even on the slides, but yes, you can only waive privilege where the substance, gist, or conclusion of your legal advice is disclosed to somebody. Or if you, in the examples of the state of mind. Another simple way to protect documents and to protect privilege is to mark them as privileged and confidential. Sometimes you'll have a lawyer who's asking you to, put together a summary for them or put together certain information, etc., so that they can give you legal advice. If you're doing that for your lawyer, I would recommend you put on the top of it privileged and confidential, so that if somebody else accidentally picks it up, they can see that it's privileged and confidential and they get the warning that they shouldn't read it. And you're asserting the privilege and saying you don't really want to waive it by having that clearly marked. You'll often see too a lot of emails from your lawyer, and you'll be like, why do I keep getting emails from my lawyer that's marked privileged and confidential? It's got that and then it's got subject matter. Can't they just put the subject matter? Again, that'll often be there, especially if you're getting advice in a commercial context and it's a big business, etc., to help maintain your privilege so that somebody doesn't accidentally read it. Only share information, only share your legal advice or the gist of your legal advice or the documents you're producing for the dominant purpose of legal advice on a need-to-know basis with people, because the more people you share it with, the less consistent it is with you maintaining privilege. If you need a support person or you're going to be sharing your advice with somebody else, speak to your lawyer first. Again, there's a difference between having a support person where you're talking generally about the stress of the matter and they're there to support you versus a support person who's in there hearing your legal advice being given to you. Use a private email address. I can't tell you the amount of times I've had clients who have come in for a personal legal matter and have given me their work email address to email. It's a no-no. Most work email addresses are monitored by your employer. Anybody can get access to it. It's not consistent with maintaining confidentiality by having your legal advice emailed to you at your work email address. If you don't have one and you're in a litigation or you're seeking legal advice, set up a private email address, set up a Gmail and just use that. Don't use an email address that you're sharing with a partner either. So, if it's a joint email address between your husband and wife, arguably, again, if you're getting all your legal advice sent there and your wife might, or your husband might open, or your wife might open it, or your partner might open it and read that legal advice, that's not consistent with maintaining privilege. Don't just leave documents sitting around, particularly if they're documents from your lawyer to you with legal advice. Again, if you're being careless and somebody might accidentally read it, you could have been said to have waived privilege because you've acted inconsistently with maintaining confidentiality. Another big no-no, and I always get, this is one that does happen sometimes in real life. Never say to somebody else when you're in a discussion, but my lawyer said, my legal advice is this and you can't do that. Because that will waive privilege. These are for kind of the businesses who have disclosure obligations to the public. There are ways of because you do have to disclose information about litigations, etc., in those public disclosure documents, but there are ways of doing it without waiving privilege. Again, there's a lot of cases out there where companies have waived privilege because in their disclosure documents, they've said, we have received legal advice that, and then disclose the substance of the legal advice. If you've disclosed the substance, you're going to have waived it. There are ways of doing it where you say, we have obtained legal advice, but you don't disclose the substance, or we haven't obtained legal advice, a whole bunch of other stuff. We believe blah, blah, blah. And it's not actually disclosing the substance, it's giving your view. But again, that's a really tricky situation, particularly when you're in the middle of litigation, because often, and I've had ones where it's big companies, they've had public disclosure documents they have to prepare, the litigation has gone over years. And we have to be really careful about how we disclose this information. And so if you're in that circumstance and you've prepared your public disclosure document, I do recommend having your lawyer have a quick look at it to make sure the way you're wording things is not waiving privilege and not going to be adverse to your litigation. You should also be careful about public disclosures in your annual reports that go to so not the public ones that go to the whole public, but the ones that go to your shareholders or in your meetings where you're involved in litigation. Again, if you're in litigation, talk to your lawyer before you have the meeting. They can give you some guidance. To the extent that you need one of your professional advisors to assist you and get involved in the litigation, like an accountant or an expert or somebody. It's always a better idea to get your lawyer to talk directly to them and to ask for the information, or to get them to create the documents rather than you doing it, because it just adds a layer of protection and makes it a lot clearer that the purpose of getting that information from the accountant and the dominant purpose was for legal advice because the lawyer's asking for it. If you do it, it's not always so clear. And again, you might have been doing it and it's not in the course of litigation or anticipated. Take calls from your lawyer in a private space. Often people will take them at work, but if you're taking them in a public space where you start talking about your case, or they can hear what your lawyer said, or you put it on loudspeaker. I don't know if you're somebody like my mum who can't hear, so every time she's on the phone, she talks to everybody on loudspeaker, and you're in a public place and somebody hears what your lawyer says, well, you'll have waived privilege. And I know it sounds silly, but these are just practical tips. If you suspect that you've inadvertently disclosed something, so you've accidentally sent you meant to send an email to Caroline Caligari, your lawyer, for the purposes of getting legal advice, but you sent it to Caroline Calamari, who's one of your clients, immediately, pick up the phone, make sure that they don't read it and they delete it. So that you have been, because if you've remedied the mistake, then you won't have disclosed. And where it's a situation where there's a limited waiver, like with an expert, make sure the person you're communicating with, A, knows to keep it confidential, 2, has procedures in place to make sure they keep it confidential, 3, that you're only sharing it for the specific purpose, the dominant purpose being to get legal advice or for anticipated litigation, and that purpose is made clear to the other person. And you make it clear when you're sharing that you're not waiving privilege in the document or advice generally. That's also why sometimes in letters you'll see that lawyers might say, I'm giving you, bill, the lawyer on the other side of bill to support costs. And they write in their letter, our client is not waiving privilege in the underlying advice. Again, it's just an extra layer of protection in case there's something in the itemization in the bill that has disclosed some of the advice. So there are ways to protect yourself. I think that's it from me. I mean, really, it comes down to 2 things. What is the purpose of what you're doing? And if the purpose is to obtain legal advice or for the purposes of litigation or anticipated litigation, make sure you maintain confidentiality.
In doubt.
Yeah, and exactly. If in doubt, ask.
We don't have any more questions sitting there at the moment. So if anyone does have any questions, do feel free to add those. We do have a little bit of time. In the meantime, I'll just put up a reminder about the resources page on our website. So we do have obviously the recordings of webinars, and this one will be added there in coming days, but also the lawyers are often writing articles and updates on all sorts of topics. So we have a really extensive library of information and articles on there. So if you're ever encountering any issues from time to time and you want to see if maybe there's a quick answer, whether it's to do with this or any other area that we practice in, do make yourself familiar with the resources page. There's a lot of information on there, which hopefully will be of good use. And if you're following us on LinkedIn and Facebook and X and so on, subscribe to the YouTube channel as well, and then you'll be alerted and aware when something new has been added. Along similar vein, the app, our Legal Ready Reckoner, is something we've been producing for well over 10 years now, and a lot of that time we've been producing it in an app version as well. So if you don't already have that, I do encourage you to download that from the Google Play Store or the Apple App Store. There's a lot of useful guide information to have at your fingertips, links to relevant websites and authorities and government departments and so on, some calculators and bits and pieces. So that's just recently been updated for the current financial year. So that's available there as well. And finally, before we wrap up, just a very quick plug for Fighting for Enterprise Success Through the Eye of the Tiger by David Sharrock, our former managing principal. It's available in hard copy and an ebook, and it really is an excellent guide to operating a business, whether it's a for-profit or a not-for-profit organisation, from a systems point of view and optimising business success in that way. So there's plenty of examples, stories from David and learnings from his journey, some examples from our firm and how we've done things, not with any hubris, but just by way of example. You can take the bits that are of interest and might be relevant for you. That really is an excellent resource. So if that's of interest, do check that out at fightingforenterprisesuccess.com. And that brings us to the end. We haven't got any more questions, but if you do have any questions, you can feel free to get in touch. I'll put up Caroline and Snarly's details again in a moment. And if you stay tuned with our emails and social media, and save the date for our next webinar coming up next month from the property law team, and we'll share details of that soon as well. So thank you very much for attending, everybody. We'll put the recording up soon. And in the meantime, we hope you have a nice day. Thank you.